years of service to the state and for her dedication to this commission, and how easy she made our jobs and how great she was to work with for us. And I wish she were here for us to thank her personally, but I understand that she's not, but I want to put that into the meeting record as well. Wendell, you want to talk about any updates on seminars and newsletters? Since you're filling in for Ressa, I know you are.
The next seminar will be our barn in Chattanooga, Tennessee, and our speakers will be
From our state, glad to know. You're ready.
Okay. Can you hear me? Okay. We'll start the legal report with the first matter. It is under tab 2 in your binders. And, oh, y'all got iPads. I'm sorry. I've got a binder.
It says tab 2 legal report on your iPad. And I think the iPad puts them in alphabetical order, so it's down there under the T's.
I don't think they have it in the tab form.
I can give one of my copies.
No, it's on there.
Bobby and you and Gary will sign that. I don't. Here, follow along. Here.
Mr. Chairman, just wanted to let you know we got the thumbs up. We're on video.
We're on video. That's good. Thank you.
Smile.
There you go. What you gotta do is read along. Next time you're gonna go just.
Okay.
Thank you.
Commissioner Collier, were you able to find yours?
Tab 2. Hard to read upside down.
There it is.
There you go. Everybody on the right page? Bobby's not.
Everybody but me.
Here, Bobby.
Oh, there, let's do it.
Ah, okay.
Yeah, just scroll across.
Yeah, I got
There
it.
you go. Everybody's got it, and we're all ready to go.
Okay, and since we're now on the record, I just want to review that we had some video problems, and prior to the video starting, we went through the roll call, and all commissioners are present, having a quorum. Ms. Whaley read the notice of meeting involving the notice that was given for this meeting. The agenda was reviewed and adopted by the commission, as well as the minutes from the August meeting. Also, the commission wanted to recognize Mr. Alexander for his years of service on the commission, and also wanted to recognize Ms. Hancock on the record for her years of service. Additionally, Mr. Wendell Hanson gave an update on seminars and newsletters, and now we are to the legal report section of our agenda, and I will just begin with the first matter on that. The number is 2013-010491. Complainant states the complainant supplied respondent firm with coins and jewelry to auction. Complainant alleges that an auctioneer with respondent stated that most items were sold and that a check was sent to respondent in the amount of $272 approximately 2 weeks prior, which complainant states was never received. Complainant told the auctioneer that complainant never received the check for $272 and was told that the check would be reissued and mailed to complainant, which complainant states was also not received. Complainant states that the complainant then sent the auctioneer an email requesting the rest of the coins that were not sold and the money. Complainant states that a day later the auctioneer replied to the complainant's email and told complainant that he would check with the bank to see if the check ever cleared and be in touch. Complainant states that complainant again made email contact requesting the status and was told that someone was at lunch and would verify the information they got back. Hearing nothing after a week and a half, complainant filed this complaint alleging that respondent did not send the check for $272 and had not returned the coins that were not sold. An auctioneer with respondent submitted a response stating that respondent did receive a consignment of coins from complainant to sell at auction, and respondent did sell part of the coins, and within the next week a check was mailed to complainant in the amount of $272. Complainant states that after speaking with complainant weeks later to let complainant know that not all coins had been sold, respondent was first told complainant had not received the $272. Respondent states that complainant and respondent agreed that respondent would continue to try selling the remaining coins. Respondent was unable to sell any more coins. Respondent states that a couple of weeks later, complainant contacted respondent and requested that the coins and money requested the coins and money owed to complainant. Respondent then called Respondent's bank and was told the check for $272 never cleared. Respondent contacted complainant and told complainant that Respondent was sending another check but wanted to make sure Respondent had complainant's correct address. Respondent states that a couple days later an email was sent from complainant including complainant's mailing address, and the coins and check were sent via UPS. Respondent states that just after the complaint was filed, but before Respondent received a copy of the complaint, the two checks totaling $272 were sent in cash by complainant and provided copies of the same. Complainant confirmed that the money and coins were received. The recommendation is to dismiss.
Move that we go with legal's recommendation.
It's been moved. Is the second?
How long did it take? Was it 2 months to get this resolved?
Let me check. I want to make sure I get it straight from all other ones. It was about 2 months, but then again, it goes back and forth to whether checks were sent before that time. But I did speak with the complainant on the phone. It was resolved based on the documentation submitted before the complaint was sent, so it wasn't as if the complaint was filed and then it was all resolved. It was kind of sent at the same time. The complainant seemed happy with the resolution of it, but it did take about 2 months. But again, I think there were problems with the mailing address, but everything was returned and accounted for at the end of it. So. I think it was just a week or two after the first auction that the first contact was made. I think the first contact was initially made pretty quickly between the two parties. They don't give a precise date, so I mean, pretty quickly, and they went back and forth, and I think there were problems with the bank, but there are copies of the canceled checks, and they're all in agreement that the money did go through to the person, and that all materials were also returned as well, all of the remaining items.
I'll second the motion.
It's been moved and seconded. Is there any other discussion on this matter? If not, all in favor say aye. All against? Next item.
2013-010971. Complainant alleges that respondent firm advertised a machinery consignment auction on AuctionZip and Craigslist, and complainant copied the text of the advertisements into the online complaint. Complainant states that the Craigslist advertisement only contains 2 telephone numbers and no names. Complainant states that the AuctionZip ad contained as contacts the names of 3 individuals and telephone numbers, but no firm name or number on either advertisement. 2 of the individuals who are listed as contacts appear to be unlicensed. The third appears to be a licensee who is the owner and principal auctioneer of a licensed firm. It was intended that a complaint be opened against the firm who was holding the auction, whose advertisements were referenced by complainant. A response was received from an individual stating that he does not know any of the people listed in this complaint and does not have any knowledge of the activity listed in the complaint. The individual states that he has an active license with an active firm, and the respondent which this complaint was mistakenly opened against was the individual's firm many years ago, which is now expired. The individual's expired firm had a firm license number, which was the same number as the auctioneer license number of the above referenced individual, who was the owner, principal auctioneer of the firm who appears to have placed this advertisement. Based on examining the complaint and the response, this complaint was inadvertently opened against the wrong respondent based upon a mix-up in license numbers. A complaint has already been opened against the correct auction firm relating to the advertisements referenced within the complaint, but it is recommended that we dismiss this respondent as it was inadvertently opened against the incorrect party, and then the commission will later address the same complaint with regard to the correct respondent that it should have been opened against. I can answer questions if that's not clear. Sometimes that's hard to explain anonymously.
So the complaint was opened against the wrong firm number, but it's been reopened against the correct firm.
I've already spoken with staff, and it's already been opened against the
So
correct
we have,
parties and sent out for
we have another one out there on
It's
this
already
same
out
day.
there. It'll be
Okay.
coming up later. But when I got this for review, once it's in legal, I can't administratively close it. And when I got to looking at the documents, I realized that the two numbers were the same, and there was a mix-up, and I caught it and have already addressed it. It's been sent out, but this person wasn't involved in any way. So that's why it was recommended. Or this firm, it's an expired firm, was not involved in any way. So
That we accept council's recommendation.
It's been moved that we accept the motion. Anybody second?
I'll second.
Ronnie seconds. All in favor say aye.
Aye.
Next item.
20130115541. Complainant attended an auction for farmland property that was advertised by respondent, a firm, as an absolute auction. Complainant states that before the auction began, respondent told attendees that it was a confirmation sale and the advertisement had included a mistake. Complainant states that only one bid was made during the auction over the phone, but the bid was not accepted by the owner because it did not reach the reserve. Complainant states that after the auction was over, respondent's principal auctioneer approached complainant about buying a tract of the property. Complainant alleges that this was a sale agreement and not auction proceedings. Complainant alleges that complainant and respondent came to an agreement about price, and the back of the contract described where the property line was to be located. Complainant alleges a contract was signed and was contingent on when the land was surveyed if the property line would be as complainant requested. Complainant states the complainant gave respondent a deposit check with the agreement that once the property was surveyed and the property line could not be worked out as complainant wanted it, then the deal would be off and the deposit money would be returned. Complainant states that complainant did sign a contract but was not given a copy immediately. Complainant went back to the property a few days later and was told by a neighbor that fencing around the property was not included in the sale because the fence was actually put on the neighbor's property and did not belong to the owner. Complainant alleges that complainant was told that the fencing was part of the owner's property by respondent. Complainant alleges that the surveying pins on the property did not match what was told by respondent. Complainant states that complainant confronted respondent with inconsistencies concerning the property. Complainant states that respondent admitted the inconsistencies and states that respondent claimed to have forgotten about these details. Complainant states at the time, complainant asked respondent for complainant's deposit money to be returned. Complainant states that complainant was told by respondent that respondent could not return the deposit check because the owner of the property told him not to do so. Complainant alleges that respondent and the property owner misrepresented details of the auction in advertisements and misrepresented details of the property that was to be auctioned. Complainant also attached a copy of a civil complaint which complainant filed against the property owner, respondent's principal auctioneer, and respondent, the firm. Respondent submitted a response through its attorney stating the auction started with one bid, and after several minutes of requesting bids, respondent received no higher bids, therefore the reserve had not been met. With the owner's consent, respondent then offered to parcel the property for the purpose of trying to auction off at least part of the property, but there were no bids made and the auction was adjourned, with respondent's principal auctioneer offering for attendees to meet with him personally later if they were interested in making a bid. Respondent states that during the auction it was made clear that any sale was subject to owner confirmation. Respondent states that with regard to the advertisement referenced by complainant listing the auction as absolute, said advertisement was never approved by respondent and the newspaper wrote a letter indicating that the running of the ad was due to the newspaper's inadvertence. Respondent states that after the initial opening bid session was adjourned, complainant approached respondent about purchasing a smaller tract of land. Respondent states that after discussions between complainant, the property owner, and respondent's principal auctioneer, that complainant and the property owner entered into a real estate auction purchase and sale agreement, which gave complainant gave a non-refundable deposit. Respondent states that complainant has participated in multiple auctions, is aware that virtually every auction sale includes a non-refundable deposit, and in fact has purchased property from respondent at auctions in the past. Respondent states that the property was surveyed twice to come to an agreement of what complainant wanted as far as the property line. Respondent states respondent and the property owner met all terms of the contract, but complainant was not satisfied with the surveys and refused to finalize the purchase. The response states that respondent's principal auctioneer never told complainant that deposit money would be returned to complainant if the agreement was not finalized. The response states that respondent and the property owner complied with all obligations in regard to the sale and complainant refused to abide by the sale agreement. Currently, there is active litigation between the parties regarding the subject matter of this complaint. Based on the fact that this matter is currently in litigation, it is likely that more information will be uncovered through the course of civil litigation, which could be pertinent to the Commission's determination of this matter. Therefore, the recommendation is a consent order for litigation monitoring. And since we've not had a matter that I have made this recommendation before, we've had this come up several times in the Real Estate Commission. I'll just explain what a consent order for litigation monitoring is if y'all are interested.
Please.
What that means is I'll draft out a consent order to this respondent firm stating that a complaint was filed. It'll give the complaint information, say there's also currently active pending litigation, and I do have copies of the complaint. It is about the same underlying allegations, and that at the time, this complaint was filed, that litigation was ongoing, and that it basically states that the respondent and their attorney signs it as well, giving them the duty to update the commission regarding any updates in the litigation, as well as giving them the requirement to notify us when the litigation is over. We can request copies of any documentation. The consent order gives them the requirement to provide that to us. Any violation of that order is a violation of, would be considered a violation of 69-19-112 B7, which would be, let's see, that's not the one here, but basically it would be considered violating an order of the commission, and that they would be under a duty to provide that. The reason that we do this in some situations where there is civil litigation is courts have the opportunity to get information that we obviously don't have available, especially at this point. And what this does is it basically puts this on hold until the court has determined it. Then we can come back with additional information, and the commission makes its decision at that time, because usually there is more information available. That's the reason for the recommendation. That's quite often what I recommend in the Real Estate Commission in situations of this type, and so that's the reasoning behind it. And you can feel free to discuss or ask questions.
Did they file a similar complaint with the Real Estate Commission on this?
They did file a similar complaint, and it's not been presented to them yet. So
I'd like to excuse myself from this because I'm very familiar with it.
as to the rest of you, if you want any further questions about the litigation monitoring consent order, I know this is something new here. In the past, my understanding was the department policy was to dismiss things and say, let us know at the end of litigation, 'cause, or at least that's what they did with the Real Estate Commission. But this way, the respondent is under an obligation by order to notify us. So.
I'd like
I
to
think it's a
follow
good
this.
idea.
I think we need to follow it, and I think we need to know exactly what's going on. This is the type of activity that this commission is set up to protect against. And I want to make sure that we don't let anything fall through the cracks from our standpoint.
Right.
If somebody would like to make a motion to approve.
Make a motion that we accept council's recommendation.
Gary has made a motion. There's a second?
I'll second.
Ronnie seconds it. All in favor, say aye.
Aye.
We do want to follow through on that, and like I said, this is the kind of thing that,
Exactly.
be sure that we're not.
And it will stay on our complaint report. I keep a copy of the file in my office, and from time to time, even if I don't hear from them, I will generally check in with the attorney and make sure.
You don't know what the timetable for this trial is, do you?
I don't. I know the complaint's been filed, the answers have been filed by the parties, and that the attorney informed me that they were expecting to begin conducting discovery shortly. Number 4 is 2013-011-581. Anonymous complainant states that respondent, firm, closed May 2013, was owned by an auctioneer who was also respondent's principal auctioneer. The anonymous complainant states that the auctioneer who owned respondent died in mid-May 2013, approximately 2 weeks before the complaint was, or 2 weeks before the complaint was filed at the beginning of June. And since that time, an individual with no license of any kind is conducting auctions at respondent's location. The anonymous complainant provided nothing but a name for the unlicensed individual, no address, and no advertisements for any auctions. A complaint was opened against respondent, the closed firm, and a copy sent to the mailing address on file with TAC, which was returned as unclaimed and unable to forward. Upon reviewing this file for presentation to the commission, legal counsel attempted to obtain information about any auctions taking place at respondent's facility and located one auction zip ad for an auction taking place at respondent's previous physical location. Said advertisement featured a sale which was to be conducted by a licensed auctioneer who was the owner and principal auctioneer of a licensed firm. All names and licensing information was contained on the advertisement. Legal counsel contacted the licensed auctioneer of the advertisement, who stated that it was his understanding that some people, he did not know who, tried to keep the auction house alive shortly after respondent's owner auctioneer passed away, but those individuals were no longer there. Respondent states that this is no longer occurring because someone rented the building, and this auctioneer plans to hold weekly auctions at the location, posting the auctioneer's license and firm license and not utilizing this respondent's closed firm's license. There does not appear to be any violation on the part of this respondent, which is the closed firm, that this complaint was opened against, and there does not appear to be sufficient information at this time to determine who, if anyone, was conducting auctions at the facility without licensure in May, and therefore the recommendation is to dismiss.
Restate that in simple terms.
I've
I've had a hard time following
I'm sorry. I try to make it clear. It's sometimes difficult. The complaint was opened against a closed firm. That's who the respondent is here. This closed firm had a owner, principal auctioneer, who passed away in mid-May. We received an anonymous complaint that had a copy of the obituary. That was all the documentation that was in there, and said, since this person died, an unlicensed person by the name of X, and it gave a name, but it was a very common name. I couldn't find any information on that individual. It didn't give an address. Has been holding auctions without a license at this respondent's facility. I went online and was trying to research it, trying to find out. The mail was returned unclaimed, so I went online to try to research, see if I could find any advertisements. Couldn't find anything about unlicensed people, but found one where a licensed individual was conducting auction about a week ago. He had his auctioneer license, his firm license number on it, and he was just using the old building, the old mailing address for this person. Contacted him to see if he knew anything, considering he was probably from those parts. He said it was his understanding that, for a couple weeks after that, somebody tried to keep it alive. He said, I don't know who the people were. That was several months before, he said, but now somebody's rented it out. I'm doing my auctions here. And he appears to, he's licensed as an auctioneer. He's an owner of his firm, and he is holding an auction there infrequently. And he said nobody else that's unlicensed is there at the time.
We don't know who the guy was that tried to hold a couple of auctions.
Unfortunately, it was an anonymous complaint, so I had to follow up on it as best as I could. And so without further information about that particular person, going after this closed firm wouldn't appear to be appropriate. So that was the reason for the recommendation. And it's likely whoever filed this complaint could be listening and could give us more information. If we could get an address or some proof of, anything on it, that would be helpful. But it really didn't give me anything to go on regarding that person.
Discussion. Anybody got a motion?
I move we go.
Bobby moves that we accept the legal's recommendation of dismissal. Howard has seconded. All in favor say aye.
Aye.
Aye. Motion passes. Next item.
52013011591. Complainant states that complainant purchased a storage building on respondent's firm's online auction site. Respondent is the firm's principal auctioneer. Upon arrival to pick up the building, complainant realized that the storage building was firmly on a foundation and could not be moved. Complainant states the complainant paid for the building, which complainant could not remove. Shortly after the complaint was filed and before a response was received, complainant followed up stating that respondent had refunded complainant's money. Complainant states that complainant did not realize that respondent would refund complainant's money when the complaint was filed, and complainant feels the issue has been resolved. Respondent states that complainant phoned respondent about picking up the building after complainant won the online bid for the storage building. Complainant states that complainant asked for more pictures of the storage building so complainant could figure out how to disassemble the building for removal. Respondent states that respondent sent complainant 6 additional photos of the storage building. Respondent states that complainant arrived and was unprepared to remove the building. Respondent states that complainant paid for the building and left it. Respondent states that respondent has spoken with complainant and resolved the matter. There does not appear to be a violation by respondent based on the information that these two parties provided me. And therefore, the recommendation is to dismiss. I'm sorry.
Back.
Yes, she'd actually, the complainant had already actually contacted back before the response was even sent, saying, I've got my money back. I didn't realize. The complaint was filed about a day or two after the auction had happened, and they resolved it within a matter of days. So.
Other discussion? Hear a motion?
I make a motion, we take council's recommendation.
Howard moves that we accept that recommendation to dismiss. Any second?
Second.
Seconded by Gary. All in favor say aye.
Aye.
Against? All motion passes.
Okay. Just have a couple more, and these are, I'm going to read a statement before these. The following cases are being represented to the Commission. They previously been authorized for a formal hearing. However, attempts at service upon respondents have warranted no result, and accordingly, it's the recommendation of Chief Legal Counsel for Litigation to flag and close these matters. If these respondents are located, or should they contact the Commission and attempt to obtain licensure, these matters can be reopened and proceeded upon. The first two matters are 2010-031-561 and 2010-031-562. This was originally presented at the January 2011 meeting. It was a auctioneer commission complaint filed after unlicensed activity was discovered during a separate unrelated investigation. The investigator interviewed the respondent firm owner at respondent's firm auction house, and she admitted she had been operating an auction every Saturday night for 2.5 months prior to her formal response to this complaint. Respondent firm owner stated that she operated under the firm license of a third party and using a licensed fourth party as the actual auctioneer. The licensed third party firm owner was interviewed, and he told the investigator that he'd only permitted the respondent firm owner to operate using his license for a single auction. The fourth party auctioneer has not been licensed since 2007. Evidence of respondent firm auction house exists in federal, state revenue filings, business license, tax, and bank records, all of which identify respondent firm owner and list the word auction in its firm name. Respondent has also thus far refused to answer the complaint, although she's cooperated with investigators. The recommendation at that time at that meeting was a consent order for each respondent agreeing to a civil penalty of $1,000 for performing auctions without a firm license. That's Section 62-19-102 of the Tennessee Code, and authorized for hearing. The Commission voted to accept the recommendation of legal counsel at that time. After the Commission authorized the aforementioned consent orders, the consent orders were sent via certified mail to the address contained within the revenue filings. Said consent orders were returned with the notation of not deliverable as addressed. A second attempt was made to send the consent orders to an address which appears to have been utilized by the respondents at the time the original complaint was filed, which was also returned with the notation not deliverable as addressed. Therefore, the Department has been unable to locate these unlicensed respondents, and the new recommendation is to flag and close as to these two parties.
I haven't auctions anymore.
Not to our knowledge, not to any information I've received. I had gotten these complaints back and given some new addresses to try to locate them. I couldn't find any information about them, and like I said, the second attempt I actually made to send them out and return no information. These are older complaints. I don't know if they've moved on, but by flagging and closing them, if they reappear, we can reopen these if we get some information about where they are. That's the problem with unlicensed people. Quite frequently is the problem.
It's been said.
Make a recommendation that we accept council's recommendation, and I have a question.
Go ahead.
You give somebody or the commission $1,000 and you send them a letter, do they have the right to come down here and represent themselves and explain why that this happened and
What happens is after you all authorize those consent orders, the attorney at that time, which is now me, I didn't draft these back then, but what they would do is draft the consent order and say the commission has authorized formal disciplinary charges based on violations of the following laws, based on the following facts, and they've offered you, the consent order is a offer to reconcile the matter informally without the need of a formal hearing. If they accept that, they can sign and pay the civil penalty, and it closes the matter. If they do not, it is then forwarded 30 days after their receipt of it to the litigation attorney, and that's when we have the formal hearings based on it. And then those people come, sometimes bring attorneys, and there's a full-on hearing. But that happens when the people are saying we're not in agreement with it. If they get the consent order and they admit to the violation and pay whatever civil penalty you all have authorized, that closes the matter at that point.
but if they call down here and ask questions, are they told that they have to send that $1,000 in? That they don't, or is it not explained to them that they have a right to come down here?
it's all explained in the letter that they can choose to accept the consent order and it ends the matter without any further process, or that they can choose to go forward with a formal hearing. And if anyone calls me, I explain that to them.
But can you come down here without engaging in a formal hearing? I think that's what he's asking.
Yes.
No, how we've done it is have the consent order and they either pay it or it goes to a formal hearing.
It's one of two ways.
If they wanted to, and I've had this come up, I don't know that I've had it come up with this commission, if for some reason they give me, if they say, well, I've got more information that I didn't do anything wrong, and they send me something that is significant enough to warrant representation, what I would do is put it back on the legal report and go, this person contacted me and gave me the following, and see if that would change you all's interpretation of it, but it stays anonymous until the formal hearing process, which is why they don't personally appear. But they are given the opportunity, if somebody calls me and says, I have more information that I did nothing wrong here, they are permitted, they're never told they can't submit that information, and it can be represented to you all. But as far as them appearing personally and talking to you, that's reserved for a formal hearing.
Has that always been the case?
Yeah. Yes.
Well, it may have supposed to have always been the case, but it's not always been the case. But this particular thing that I'm talking about was one that I excused myself on, okay? And that's history. But going forward, if we give somebody a $1,000 penalty from what you read, I think that it should be a little bit more explained a little bit different when you send your letter out, that you don't have to pay this, you have the right to appear before the commission.
It is explained in the letter that I send out to them, and my contact information's on there. If they have any questions, they can call me. Quite frequently, I almost never have someone pay something without calling me. I rarely just receive the check in the mail. Usually, I will get the phone call and I tell them, it's outlined that they have 30 days to sign the consent order, and if they don't, it proceeds to a formal hearing before the commission. It's all outlined within the letter that I send to them. I mean, I'd be happy. I always put at the bottom, if you have additional questions, contact me.
Could next time, could you show us a blank
letter of what I
that you send out? No names?
I think that would be fine.
Yeah.
I'd be happy to bring one back at the next meeting if that's, sure.
Basically, what you're saying is they got two choices. They can pay it or come down for a formal hearing unless there's additional information in which might reopen it, and we would change the decision against $1,000.
And you don't have to, but
Yeah.
if I get something that I'm looking, and sometimes people will just, I have had with the real estate commission where somebody will just send me a letter basically restating everything they said, and I've said, this is not sufficient to represent, but if I get email correspondence that, maybe something that wasn't told before is unfolded, then I do that is the practice to represent if it's considered sufficient enough that you all might possibly reconsider your recommendation.
I think where Howard was going with this, and I may be wrong, correct me, is he was saying, rather than get tied up in a formal hearing where it could cost, they might have to get an attorney. Can't I come down here and we talk about it ahead of time? I think that's where he was headed with that.
That's how I understood it as well. The problem with that,
Sorry.
The problem with that is if they come down and talk and you don't change your mind, the fact that they've appeared and talked before the commission has potentially tainted the formal hearing process. See, it stays anonymous until the formal hearing so that the board only hears the facts. They don't know who the person is. They don't know what company they work for, what part of the state they're in, until such time as it's a formal hearing. So it seems rather, there's a distinction between the original presentation to the commission that is anonymous, that the commission makes a determination that there appears to be, based on the facts presented, probable cause to proceed to a formal hearing. However, in lieu of that, we being the commission, offer the respondent the opportunity to settle the matter via consent order and the payment of a civil penalty. At the time that is sent, it's explained, you don't have to do this. You don't have to sign. This is not a fine that's been levied by the commission to you.
Consent order.
It's a consent order. It is an offer that you can resolve this matter by agreeing to the facts set forth in the consent order and the payment of this recommended civil
Can
penalty.
they negotiate the consent order?
The only way you could negotiate it is if, they contacted and said, I don't agree to pay $1,000, but I'll pay you $5 and sign the consent order. Typically, we don't like to do that because you have cases that, we have to come back and go back and forth between, only you could approve
Only
that.
you
So
all
we
could
would have to
approve
bring
that.
that back to you to say, maintaining the anonymity, he says he'll sign the consent order but pay $500. Do you accept that? And commissions typically have not liked to do that.
At my second meeting, some of you weren't on it, but you all told me don't do that because I actually got a call and brought it back not knowing, and you all were like, is there new information? Well, then no, we don't want to reconsider it.
Right.
So if that's changed, let me know.
No.
But just based on a pure, well, I won't pay you $500, but I'll pay you $250, you all have said, no, that's not what we offer.
This is not unlike the real estate commission. Real estate commission does the same thing.
Right.
We don't have any reach beyond licensees, though, do we?
That's the difficult aspect. Yeah, I mean, we can turn over unlicensed activity to the local district attorney.
Do we do that?
We have done it in the past. It's not real high on their priority.
Well, I realize that. They'd
And
rather-
so,
yeah.
that's somewhat
My
challenging.
point is, when Mr. Auctioneer gets a letter, and he opens it up, and he's been fined $1,000, it scares the crap out of him to begin with. Am I gonna lose my license, blah, 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 what all goes through your head? And I think that everybody in the world deserves an opportunity to explain themselves.
Have that.
Well, when you send something to somebody like me that doesn't have a law
Sorry.
right to come before a formal hearing,
Well, they can
That-
also present
that
more
then-
information to the counselor. They
that
don't
then
have to come
tells
here.
me that I've got to hire a lawyer and come down and defend myself for $1,000.
But you can also present additional information to council. You don't have to do it to us. If they've got more information than what we have in those facts. I don't know. The process is what the process is. We can't change
The
it.
process has not always been this way. The process has been, I've sit here, not in the last 2 or 3 years, but before, and people would come down and sit right where he's at and explain themselves. And a lot of times, the commission never moved. A lot of times, the commission changed their opinion. But having said that, I'm through.
I'll be happy to bring a copy with names pulled out of the letter that I send next month at the meeting.
We need a motion on this particular case.
I think there was a motion,
You made
but
that
not a
motion. Is there a
second.
second? Seconded by Bobby. All in favor say aye.
Ah.
Next item.
3, 4, and 5, 2011-01-8941, 2011-01-8961, and 2011-020-281. These were presented in October 2011 at the meeting at that time. These 3 complaints all allege misrepresentation at 3 separate auctions. The firm in question is not licensed, and the auctions were not conducted by a licensed auctioneer. Additionally, the respondent did not answer the complaint. the, I guess, recommendation at that time was to authorize a consent order for a $2,000 civil penalty for violations of Tennessee Code Annotated Section 6219-102, subsection 3, for a total civil penalty of $6,000. The decision at that time was the Commission voted to issue a consent order to cease and desist all unlicensed activity and to assess a civil penalty of $7,500. After the Commission authorized the aforementioned consent orders, the consent orders were sent via certified mail to the address where the complaints were sent. Said consent orders were returned and service was not achieved. Based on a research of possible alternate address for this unlicensed respondent, a second attempt was made to send the consent orders, which was returned with the notation vacant, unable to forward. Therefore, the Department has been unable to locate this unlicensed respondent, and the new recommendation is to flag and close.
So this goes to the same thing we were talking about, having no reach to those who are unlicensed.
Well, and the problem of locating them. With our licensees, they have a duty to keep their address current, and these people frequently move about, and that makes it difficult, especially when service was never obtained. You know, it seems the first consent order was returned, and I sent, before trying to, I tried to do some research and marked it as well, and found another possible address. Again, it was returned as vacant, and I couldn't find any information about any other possible addresses. So.
I noticed in the Memphis area, we have these people come in and do these hotel auctions, and they just fly in and fly out, and they're in and gone, and they're doing these different auctions, and there's no way to catch those guys, and I don't know how we stop that.
This one, the difference is, I don't know. It's not even a company from out of state where we can even figure out, even though they've gone back out of state, I don't think there was any information about where they are. So, but like I said, if we get further information, we can always flag them and then reopen them because, we're certainly interested in pursuing it, but without an address or a way to get a hold of them, we would be holding a default hearing with nobody here. And
Motion.
I make a motion, we accept legal's recommendation.
Made by Howard. Second.
Second.
Second by Bobby. All in favor say aye.
okay, what do I have next?
That it for the legal?
That's the end for the legal report, but I do have two more things for y'all. So
Date on the proposed rules?
yes, and I have handouts of those because I had sent them to some people for review. I'll pass them out. Don't worry about that.
Thank you.
As you all know, we've been everyone except Commissioner Collier. This is his first meeting. We've been working on some changes to existing rules and possible new rules. Up until this month, we kind of had them in bullet points. We'd been tweaking them, changing them a lot each month, and Commissioner Alexander was a driving force behind it, so miss him being here today to help us with this. But I have put these rules in the notice of rulemaking hearing stapled packet you have into a red line version, which means if we are altering an existing rule with what we had, it's got things that are crossed out that we're removing from the old rule and underlines things that we're adding. It's the same substance of what we've done before, but this is the formal document that it needs to be put in that we file with the Secretary of State's office to notice our rulemaking hearing. You'll see on the first page that I have posted a February 3rd, 2014 rulemaking hearing date. There is a certain amount of people that have to sign off on this after you all accept it, do our analysis, and move forward before we can post it to the Secretary of State's office. It then has to be on file with them for at least 50 days. So that's why that's pushed out several months. In light of as having a commissioner come off and having a new commissioner come on, and this is all brand new to him. I did want to give him an opportunity to look at the formal document as we would review it next month, as well as provide you all with the attached memo. This includes the analysis that we will be required to do before we can send this up to be filed for a rulemaking hearing. Next month, I will come back under this regulatory flexibility analysis and as far as the other considerations that are required, and I'll have some bullet point thoughts to jump the discussion off, but we will be required to consider each of these things with respect to the changes to the rules we're doing. In light of the fact that we'd had the turnover, I didn't want to move forward with Commissioner Collier not being familiar with the substance of the rules. I thought giving you each a copy of the paper rules and what we'll be considering each month. If you want to make any last minute notes, we need to make any substantive changes to these rules before we move forward. We can make some slight changes at the rulemaking hearing, but nothing major. So in light of wanting to give him an opportunity to fully review it and let you all see the considerations we're having, I don't think it will affect the rulemaking hearing date at all, but I'd like to come back and formally do the review next month. But I wanted to provide you with copies. These are confidential. Don't give them to anybody else because they're not. We haven't considered them yet, but I thought giving you paper copies, if you wanted to make some notes, we could have a very meaningful discussion next month on this exact document. So
I appreciate you doing that, and I think that's a good format for us to be able to review it and really, guys, I'd ask you to do your homework between now and the next meeting and be very up to date on what these rules are.
And Commissioner Collier, if you have any questions in reviewing it, since you're a little behind the eight ball, please feel free to contact me and I can maybe assist you.
We would like to have a vote on this at the next meeting, is that correct?
Right, we would have to complete that analysis and then you would all vote whether to proceed with filing these rules for a rulemaking hearing. That would be the process. But I wanted to give you a memo with what we would be considering as well. So if you have some thoughts on any of them, you can feel free to jot those down as well. But I will have a more detailed memo to provide discussion points as a jumping off for each of these to assist y'all with your analysis.
Appreciate the hard work on that, guys. Y'all have any questions about that? We've been kind of going on back and forth with this for some time. Like I said, Marvin will be missed because he was pretty adamant about a couple of things in there.
Right, and I just thought we can go through the formal analysis next month, and it should not affect the ultimate rulemaking hearing date.
I like the format of that. We could that allow us to kind of read it and understand it a little bit better, and we're all agreeing that we're going to do our homework, right, guys?
All got paper copies, so if anybody loses theirs, I want an email, and I'll send you another one.
I have a question
Sure.
already. Lost it. It was so plain. Yeah.
Did I hear you say something about a licensed auctioneer calling bids at an auction gallery? I think that's the first one on page 2. It's adding new paragraph 2. This is a verbiage that had been given to me, suggested by one of the commissioners that we discussed before, saying that a licensed auctioneer shall not accept offers to call bids at any auction house, barn, or gallery if the auction doesn't hold a gallery license. That was something that had been recommended, but like I said, if one of you all doesn't end up liking that, if that's something we want to scrap next month, we can always do that. That had been something we had discussed at several prior meetings, though. Okay. Like I said, you've got a month to look at it, and I know you'll take your red pen to it and have a lot of probably thoughts to. I just want to be sure that these are worded in the final format the way that you all wish for them to be. So there have been no major changes to the substance, but putting them in the rules sometimes might change your perspective.
Right, exactly.
And there's one final thing on my report if you all are
right
ready
ahead.
to move forward. Last month we had contact from Ohio regarding this reciprocal agreement. It had been misplaced between Ohio and Tennessee. The staff attorney there had sent over a proposed reciprocity agreement, and that is under well, it says tab 3, but it's on the iPads. Do you see anything about reciprocal agreement between?
Tab 3 on the
Okay.
iPad.
At that time, you all had expressed concern with one provision in it because in paragraph 2, it did not state specifically that the licensed auctioneer in Ohio needed to be domiciled in Ohio, and that's required by our statute. So I contacted him with that concern, and he was agreeable to adding that in. Now, there are two versions of the same agreement because I was reviewing our statute, and I didn't know how you all would feel about it. You'll see that there's one titled at the top, Reciprocal Agreement between the State of Ohio and the State of Tennessee relative to the licensing of auctioneers and apprentice auctioneers. And then there's one titled, Reciprocal Agreement between the State of Ohio and the State of Tennessee relative to the licensing of auctioneers. The substance of these two different reciprocal agreements is no different from one another except that one includes apprentices, one does not. I noticed after the meeting last month that the agreement that he had given us that you all had taken a look at did not include apprentices. Our statute regarding reciprocity allows for license recognition through reciprocity for apprentices as well as auctioneers. However, I did not know if that was you all's intent. They expressed no real problem with having apprentices included, so I drafted one with and one without. I'd like for you all to take a second look at, just the substance of this and let me know which one of these you would like. He said other than that, he let me make my changes and said I could get signatures from you all and send it back to him, but I didn't know what you all's thoughts were on apprentices because it was not included on the first draft, but our statute does allow recognition, so.
Auctioneer, reciprocal, and you'd have to have a principal auctioneer in Ohio to do that with, wouldn't you?
That reciprocates. That reciprocates.
Do they have apprentice auctioneers in Ohio?
They do.
Is it similar to the same requirements as our?
2 years. It's not 2 years.
I have my emails with him.
Wendell probably knows. Wendell, do you know?
I think he might be right. I think it's 1 year in Ohio. So if you all want to restrict this to regular, just auctioneers, that's why I provided 2 copies.
What do we do with apprentices in other states?
What do you mean? What do we do?
I mean, do we reciprocate with apprentices in other states?
I don't generally handle the.
We do?
Yes, we do.
Well, how do they get to reciprocate? Does it come before the auctioneer commission?
No, if it's an apprentice that's out of state, we don't have them very often, but if it's an out-of-state apprentice, for them to apply for reciprocity as an apprentice or an auctioneer, they have to actually reside in that state. They can't move here and apply after the fact. So based on your statute, they have to have a sponsor that resides in the same state. Like maybe they're going to come in and do an auction and they're wanting to bring their apprentices with them, or if they live in Virginia and they're going to come right over the state line, then their firm and their sponsor would have to reside in the same state and be licensed in Tennessee, or they would have to come before the commission for you to determine if you
Don't ever come before the commission?
For a reciprocal apprentice, yes. We had one, I think a couple of years ago. The firm and the sponsor were in Tennessee. It was a father-son. The son lived in Florida and wanted to reciprocate to come to Tennessee periodically, but not one,
He didn't have a principal in Florida?
no. And his license was denied.
But you said those don't.
That doesn't come up very often. Had his firm and his sponsor been in Florida and licensed in Tennessee, you guys wouldn't have seen that.
Or if a Florida auctioneer wanted to bring his apprentice with him to Tennessee to call bids in Tennessee,
Yes.
then that's when he would reciprocate with the Tennessee and
Yes.
okay.
I don't see nothing wrong with that.
I don't see anything wrong with that either, but you cannot get a reciprocal apprentice auctioneer without having that principal having a Tennessee license as well,
Yes. And the firm that they're working for.
and the firm as well.
Yes.
Okay. I follow that.
You all want to review just this, I know you looked at it last month, but Commissioner Collier did not look at the rest of it. So we want to go with the copy that includes apprentice auctioneers is what I'm taking from this.
That's the first one.
I'm not sure, I don't have an iPad, it's titled.
They're exactly.
It says
Okay.
and apprentice
If it's,
auction.
yes, then that's the one, and if you all would like to just look at the substance, like I said, it did change, I did change the wording in subparagraph 2, or the paragraph 2 regarding where they're domiciled. That was the change, but wanted to let you have the opportunity to review again, because we would sign this.
So our apprentices can get an apprentice auctioneer's license in Ohio?
Right, that's what this agreement would
Okay.
provide for, as well as regular auctioneers, of course.
Have any idea what the education requirements are for their apprentice auctioneers? Is it similar to the state of Tennessee, or?
Ohio, can a apprentice auctioneer call bids without the principal auctioneer being present?
Does not address the education in there, and I don't know offhand. I mean, if you're not comfortable with it, I can look into it and determine that. But I don't know off the top of my head.
Help us with that, Wendell. The educational requirements for apprentice auctioneer in Ohio. One-year apprenticeship.
I
Okay.
got 2 here.
Pass the state exam.
Does the principal have to be present when the apprentice is calling bids?
Yes,
Similar to here.
similar to here, except it's 1 year instead of 2.
Everything else being
Yeah, the
fairly.
only other state that has a 2-year apprenticeship right now is Kentucky.
Okay. I want to make a motion on this?
Would us having 2-year apprenticeship and them having 1 year, would that create a problem? I mean, if
More
Other
problem with the
s-
auctioneer than it would the apprentice.
if another state's going to have a reciprocate with us and they only have to have 1-year apprenticeship, then you have to have 2 in Tennessee.
They have to be a resident of Ohio to do that. They can't be a
Right.
Tennessee resident, go up and get an Ohio license and come back down here and get a reciprocal license.
Right. They were still in Ohio after, that 1-year apprenticeship. They could apply for reciprocity as an auctioneer here, but they could have done that even if we didn't include auctioneers because, if they're a full-fledged auctioneer there, we would have granted reciprocity anyway after that point.
Go with the first one.
And I'll pass it around for signatures when we've just concluded, but
The first one.
the one that includes apprentices.
The one that includes apprentice auctioneers. Is there a second to that motion?
I'll say.
Seconds it. All in favor say aye.
No.
All against?
No.
4-4.
all I have for my report. Unless you have anything else for me, I think we can move on to the administrative report now.
At this point, let's take about a 10-minute break, and we'll come right back at 10:35. Bobby's happy. Okay, we stand back in session after our break, and who's going to give our complaint comparison report?
I will be.
Okay, you might well speak up so they can hear you.
Okay. In tab 4, you will find the comparison from 2012 to 2013.
Okay, all right, give everybody a second for tab 4.
Library.
It's under books.
Oh,
You know those things away when you went to school.
Yeah.
tab 4.
There you go. Okay, well, I think we're all on your page here.
Okay. The top portion has the complaints for 2012. The bottom is for 2013. In 2012, you had 67 total complaints, with 54 of those being over 180 days. Currently, you have 54 complaints, with 41 of those over 180 days.
A large portion of those are still up to that one case that's going to hang out there till I'm an old man.
It's been here since before I got here.
I know.
So. Yes, large portion. I don't have the exact number, but I think it's in the upper 30s.
Commissioner Collier, there's one complaint against an outfit here that was started back when, you remember, 2011?
2010.
2010.
Yeah.
40-something complaints. They're no longer in business. There's a lot of legal proceedings going along with that, and that's where our numbers are out of skew here a little bit. But other than that, you take those 40 off, and we're about, what, 14, 15 complaints?
Those that we closed this morning, are they in this figure
Yes.
also?
They're in this
Yeah.
figure, and actually there's only 41 over 180 days at this point. You have 54 total complaints, but only 41 are over. And I
We
think
have
the upper,
13. We have 13 complaints total, really, that are out there that don't relate to that case. Is that right?
I think less than that. of
Less
the
than that.
over.
I think you had 36 or 37, so the ones that she represented this morning, that should take everything off the 180 days with
Okay.
the exception of that one
Okay.
case.
So we're staying on top of our cases as they come along, and we're getting them handled.
They've all been given to you.
Okay.
And most of these actually have had some sort of clock stopping action. They've gone
Mm-hmm.
through to litigation. They're not things that are waiting to be presented to you. I think they've all.
Do you know of any formal hearings that will be coming up in the next few months?
I don't. I can check at our next monthly meeting,
Okay.
and if we don't have one next month, I can try to give you a more updated report on that. Mark might could have answered that question. I know he stepped out. There were some issues at a couple
Right.
other meetings, but I'll try to get you an update on that next month.
Okay. All right. Good deal.
Actually, I have the performance measure data, which is a measure that the division uses to judge how well we're doing on complaints. And Auctioneers is currently sitting at 93%, so that is representative of the fact that you move, your complaints come in, you handle them, they reach a clock stopping action within. So just the fact that they're older than 180 days does not mean that we've not taken some sort of action on them.
Perfect.
So, tab 5.
All right.
Okay, tab 5 contains your current budget report. These numbers are as of the third run of June. As you know, the state's fiscal year runs from July 1st to June 30. And this is the process of closing. This is the third run. Actually, next month, I believe, we'll actually present your budget closing report, and you'll actually see how you finished for the entire year. We'll have everything finalized.
This doesn't look like a budget report that we're looking at.
Tab 5 isn't?
It doesn't look like it.
They're looking at
That's
the
the
first
the
page.
revenue.
Next one over.
Yeah.
You're looking. The first page you
Okay.
have is the revenue. The second page is actually
I
your
got you.
expenses.
All right.
My apologies.
It looks more like a budget. Okay.
It is very small. Next month it'll be very concise, and you'll actually have a 4-year look at where your revenues and expenses have been. And someone from administration will be presenting that information to you for your final and going over and seeing where we're going to be in the years to come. So it'll be a little bit more meaningful, rolled up and seeing the entire year all at once. This
Is
report.
there anything that stands out in your opinion is that we need to take a particular look at?
Not at the moment.
Early into the year, so.
Yes. We actually only have July and August financials for this fiscal year. We run
Gotcha.
about 30 days with how the state processes and runs their financials, because we have to rely on finance and administration. They're the bookkeepers. Nothing.
They'll be at the next meeting to go over this with us?
Finance and administration will not be, but regulatory boards administration.
Okay.
Myself, Rachel Powers, and even possibly Assistant Commissioner Giannini will be appearing to discuss
Any
the.
action that we need to take today?
No, sir.
Okay.
This is just for informational purposes.
Any questions about that?
Tab 6. And forgive me if I mispronounce this. Is it NOLA?
Hold it, right?
Okay.
Close enough.
The National Auctioneer License Law Officials Association provided some information, and that is what is contained in tab 6.
I was at the conference and show. We had the NOLA meeting, and we had greater participation this year than we've ever had in the past. Still not quite sure what can be done to generate more participation by the different states around the country. They struggle with membership and with people giving responses and really having a meeting of the minds, but there needs to be a more definitive agenda on the part of NOLA in terms of, what are we trying to accomplish here. They're trying to standardize more from state to state, the laws and regulations, and it's very difficult.
That is all I have in the administrative portion.
Okay. Is there any news about, maybe I shouldn't ask this question, about is there going to be a new appointment for Donna's position, or is that something that y'all are going to consider over the next
That is
few
something,
months? or-
That is something Assistant Commissioner Giannini is assessing and considering at this time.
Personal question. I wanted to see what was going on.
Feel free, Susan and the staff in the board office do a fabulous job. I'll provide you with my business card if you have any questions or concerns. In the interim phase, feel free to reach out and contact me or the Assistant Commissioner.
Is there any other unfinished or new business to be brought before the commission?
Bill, Bobby up there,
Oh, you have a student that
Yeah.
they haven't actually applied, they're applying for class.
Yeah, and they're planning on coming to school in October. And this, I told them I would pose this question to the commission, and I did. large corporation, has a presence in Tennessee and most other states. Person that is coming to school, went to school in Canada, and they are a resident of Canada 25 years ago. They applied to come to school in Tennessee in order to hopefully get an apprentice license in Tennessee with one of the auctioneers that has a Tennessee license here in Tennessee. So my question, would that be a license, a person from Canada coming to school, meeting the qualifications, and sitting to take the apprentice test? Would y'all allow that and allow them to apprentice with an auctioneer that's domiciled in Tennessee?
Live in Canada,
They live in Canada,
but they want to apprentice.
and they work for the international company. And this corporation has auctioneers that go all over the world.
I take it the sponsor is a member of this corporation that lives in
Yes.
Tennessee.
Yes. And the question is,
I thought there was you have to live within a certain,
not auction.
Real estate's got to have
real
the
estate,
auctions
okay,
done.
auction does not.
We make
Right.
should.
I've always thought that the apprentice had to live in the state of his sponsoring auctioneer.
Unless we waive the rule.
I'm helping Julie look. I think that's in your rule, but it's up to,
Basically, the rule says that they must reside in the same state unless the commission waives that rule.
Right. We have the
You have the
authority
authority to do that.
to waive the rule, right.
And, my position is, it doesn't matter which way y'all decide. I just don't want this person to come to school and expect to,
Yeah,
after he
right.
attends school and says, well, you let me come to school, Wendell.
Right, right.
Right, he just won't on the front end.
Yeah, I would rather tell him up front. He's already registered to come to school in October.
Does Canada have an auctioneer law?
They do.
They have an apprentice law?
Not that I know of, just an auctioneer. But they have schools in Canada, but the thing that he stressed to me is, and I went to CAI with this individual, he's been an auctioneer in Canada for over 20 years. And he was one of my classmates at CAI. And he used to work with Ritchie Brothers. They went into a family business in Canada. He sold his business. Now he's going back to, I shouldn't have said the name.
Right, I understand.
But y'all knew.
No, it was anyway.
Okay. But he said, I want to get my auction license. And he'll be licensed he'll go for licensure in all the states. As you well know, Tennessee's one of the toughest there is to get a license.
SCAI,
He is CAI.
I don't have a problem with it.
I did find the rule, if you want me to read it, but it's, as Mr. Hanson said, it's within your 0160-01-.12. It's titled Apprentices Sponsor Supervision. Subsection 5 states that all sponsoring auctioneers shall reside in the same state as her apprentice auctioneers. However, in appropriate cases, upon good cause being shown, the commission may waive this rule. So that's what he was referring to, but just to point you to the direct rule, I did locate that, so.
I have one more question.
And I'm not representing him, by the way.
Well, it seems to me that you are.
I'm
but-
not. I'm asking the question because I want to say, no, cash your plane ticket in if in case that y'all
Let
wouldn't
me ask
approve
you this,
it.
can he make that application prior to signing up for your school? So that he would
He's
know?
already signed up for the
He's
school and
gonna
he's
go
not
in
made
October, it's
application.
a little late.
But I told him and I told his corporate office I would pose the question at this meeting
Well,
today.
I have one question, then I'll be satisfied. If he lives in Canada, he's going to get an apprentice auctioneer in the state of Tennessee. How is he going to, is he going to come down here and help conduct auctions in Tennessee?
That is his intent.
My question was, is he? Will he?
If his supervisor, if his sponsor auctioneer is present.
I mean,
He
if
can't legally otherwise, and if you know the corporation I'm speaking of, they don't do things illegally.
If
Oh,
you
they just
all,
pass a law and make it legal.
That's right.
if you all would like to
you know.
maybe have him write a
What the
letter
heck?
in or something like that, I mean, you
I'm
know.
sorry, you
Oh,
Bobby
stepped into that
interrupted
one, I'm
me.
sorry.
I was gonna say if, you know, maybe he could write a letter in to us. I don't know when he's scheduled to start school, Mr. Hanson. I mean, I know that you,
19th of October is school day.
okay.
Taking a long time to get that logbook filled out. What, 2 sales a year, 3 sales a year?
Typically, we don't see the applications until after they sit for the exam. This is different than the one we were discussing earlier that was out of state because that was a
Hard for us to
reciprocity
give a
application.
pre-approval on that.
Yeah. This wouldn't be reciprocity since he's actually gonna do our education and our exams. We don't have an application.
And like I said, I'm not representing this person or this corporation. I just
I understand.
said I would
It's just-
pose the question.
Since you are my friend and you are not representing this person
Or this corporation.
or this corporation, as a member of this commission, my personal opinion is that this won't work. I don't know how you could ever complete your apprentice program, but maybe other commissioners can change my mind.
I have a tendency to agree with Commissioner Phillips.
Well, may I address your comment? He may never want to advance the license from the initial license.
They come back in 2 or 3 years after we're all gone,
Okay.
with a variance to get his auctioneer's license too. So
Just an
it's
informal poll of the commission tells me you'd have an uphill struggle on this one.
Not me.
He would. He would. He would. If that's what you're looking for.
I wanted to pose the question. I told him
Yeah.
I would pose the question.
Not impossible, but there's some headwind there.
Does he not have?
Yeah. he would.
Yes.
Yeah.
He's
I think
asking.
I think Wendell was just trying to do him a favor to save him a tuition.
I'm trying to
Sure.
help him by, if he's gonna waste
Save a
9
plane
days out of.
ticket and a tuition.
He doesn't need to come to auction school. He does to get the license, but he
Right.
doesn't because he's
Right.
Certified Auctioneer Institute graduate, and he's been to auction school in Canada. He just wants to get the Tennessee license.
Right.
And I told him I would pose the question, because I would feel really bad if he came here and spent 9 days with me on stuff he already knew, and, yeah.
Got turned down.
Yeah, just
Right.
spend
And
9 days with.
then he was turned down by the
Yeah,
licensing
he's
board.
facing some headwind. You might tell him that.
Okay.
Because we wouldn't normally present it to
Right,
you until
right.
you've taken the education
Right.
and the exam.
This is all informal.
This
Yeah.
this is
This is hypothetical.
hypothetical.
Hypothetical, that's a good word.
Mr. Chairman.
Yeah, you got the entry we're looking for.
Well, I move with adjourn if there's.
Second to that? All in favor, get up and leave.
I still think we need to keep we